Hello and welcome to the Temple Mount podcast. My name is Shogun. Today is episode 3 of the Temple Mount podcast, in addition to the one Church of the Mount recording that we did, which is 4 in total. But today we're going to talk with Randmguy, one of my Templars on the server and a good friend. And I've done multiple roundtable podcasts with him before, and he's got a really interesting perspective, focusing a lot on sort of language and law and thank you. Some of the misconceptions people have about laws and the meanings of words and how to think about things like contracts and money. So today we're going to get into contracts, the legal magic and the linguistic magic of contracts. Going to be really interesting. Before we do, though, make sure you've joined the Temple Mount server. You can find us on Discord. We're on Discord. And you can also find the Temple Mount podcast on SoundCloud and YouTube. And you can find all of that in the Temple Mount Discord server, where we record this podcast every day, usually at about 9 p.m. or 9:30 p.m. Keep an eye on the announcements channel for upcoming events. That being said, welcome, Randmguy. How are you, my friend?
I'm doing great, Shogun. How are you doing, brother?
I'm great, man. I mean, as you can probably know, you've been here with us all along. Things are going fantastic, and I'm extremely grateful and pleased about the community and the work that all the team has done and how everything's come together. I couldn't ask for more. And on the same note, having you here to do this podcast is just, one more part of that, right? So
I appreciate it. And I really appreciate being the third podcast, the third official podcast, because I like threes. I like doing threes in a lot of ways. So that's good stuff. Appreciate
100%,
it.
brother. So again, like I said, you talk about money, you talk about language, you talk about law. And basically, if I could kind of frame it for you, you sort of think most people don't think about these things properly, and because they don't think about them properly, that's why it works on them. Would you agree with that? Like it's a trick.
Absolutely.
Right?
Absolutely. Because everything is a contract, and most people just don't know contracts, to the extent that most people think that a contract is really about having something written down on a piece of paper with ink and having to sign it, when the reality is that's not the contract. That's merely the memorialization of the contract. And in fact, this is something that, again, most people don't realize. Everything along the way, codes, statutes, regulations, it doesn't matter across the board. If it's coming from a government agent, a GovCo agent, it's an offer to contract. But it gets kind of complicated in contracts, which is part of why I wanted to cover some of the basics, some of the stuff that actually ought to be taught in school, somewhere around maybe 5th, 6th grade at the earliest, but for sure by 7th, 8th grade. Kids are starting to understand some things fairly well, and they're smart enough to understand some pretty basic, simple things. Because first is the offer, just basic contract law, basic contracts as it stands. There always must be an offer first, and an offer must be accepted as it is. If it's not accepted as it is, it's not an actual acceptance as much as it's a rejection and a counter offer. So let's say Shogun and I are talking about purchasing something, say a water bottle, and he wants to sell it to me for $20, and I don't want to pay $20. I want to pay 15. So I counter offer with saying, how about 15? That literally is a rejection counter offer. It's not actually the same contract even, because that original contract that he offered at $20 is now gone. And now there's a new contract offer on the table, and I've made it. If he comes back and says, I don't like 15, I want to go 17.50. He just rejected my counter offer and made a new offer. Now there's another new contract. We've literally gone through 3 offers of a contract at this point and no acceptance. But if I go ahead and accept that 17.50, now I've got to come up with what is known as sufficient consideration. Sufficient consideration is the area where we'll do another podcast on this, but what most people would consider money. But money is, again, it's a whole nother topic, but essentially money is whatever 2 people agree upon at the time of contracting. So let's say that one of my favorite analogies is you've got a peppercorn, I've got a steak on the grill, and I don't really care about the house, so I'm going to trade you the house for peppercorn because I want to crush that peppercorn up and put it on my steak, make my steak taste yummier. Most people would think, well, wait a minute, sufficient consideration, a peppercorn for a house? Well, it doesn't have to be equal consideration. It just needs to be sufficient. So if it's sufficient, and if I agree upon it, the money becomes the peppercorn and the house. That's sufficient consideration. It also comes under what's known as detriment benefit. We both are incurring a detriment. You're going to lose the peppercorn. I'm going to lose the house. I'm getting a benefit because I'm getting the peppercorn. You're getting the benefit because you're getting the house. At the moment that we've decided house for peppercorn, at that moment is known as a meeting of the minds, aka formation. That's the contract. That is it. That's where it's at. It's all in the head. There isn't anything on paper. There's nothing in writing. We just simply decided the peppercorn for the house. That's all there is to it. But if you don't have a meeting of the minds, there is never any formation, thus there is never a contract. It is pretty simple from that standpoint. Now, let me give you an example of how easy a contract can be entered into and performance done. And this will be what's known as a unilateral contract. Also, it would be an implied contract because we're not going to actually be using any words in this scenario. You walk into your favorite sandwich shop for lunch. You see the girl behind the counter. She sees you. You nod to her as if to say, I want my regular. She nods to you as if to say, as soon as I'm done with this guy on the phone. A couple minutes later, you look on the counter. There's your regular sandwich. She's just done the performance of the sandwich. Now you need to perform by going and paying for it. It's really that simple. When you walk through a grocery store, you fill your cart up with stuff. As soon as you walk to that register and you start to put stuff up onto the counter, you're now accepting their offer. The food, the groceries, everything that's on the shelf, that's an offer to contract. As soon as you walk to that register, now you're accepting that offer. Most people don't realize that it's that simple, but it really is that simple. The problem gets even more complex when we start looking at things outside of the basic daily, such as, like I said, codes, statutes, regulations. These are all offers to contract. The problem with all of those, unlike the scenario that I gave with Shogun and I were talking about, whatever, trying to come to terms and conditions, there's never, ever a real party of interest. If you're talking to a cop, he's not the real party of interest. He's going to say it's the state. If you're talking to an IRS agent, he's not going to be the real party of interest. He's going to say it's the IRS or it's the state, the Fed. This is going to be everything across the board. DAs are going to say the same thing, judges, so on and so forth. Well, in the world of business and in the world of contracting, because they're all pretty much the same, an agent cannot exceed the capacity of the principal for which they claim to represent. Well, if a piece of paper cannot have a conversation with you to where you can ask it, what do you mean by this word? What do you mean by the word accept? What do you mean by offer? What do you mean by consideration? If you can't ask these words and get an answer from that stack of paper with ink on it, how do you have a meeting of the minds? And if you don't have a meeting of the minds, thus the formation can never happen. Of course, the problem with this is, again, most people don't recognize it. And there's a legal maxim that courts stand on very sternly. And that is, he who will be deceived, let him. So literally, if you have an offer in a courtroom where they're offering you a plea deal, it's an offer to contract. A plea deal is an actual contract. It's not even a conviction. There's court rulings on this. Well, you can counteroffer. If they're offering, you don't even have to accept. They want you to believe that you have to accept, or you've got other penalties coming. But those other penalties are all offers to contract. Even to go to trial is an offer to contract that you don't have to accept. They want you to believe it, because he who will be deceived, let him. And they thrive on letting you be deceived. They thrive on your ignorance. That's why I was saying this is something that should be taught to kids starting as early as fifth or sixth grade, at least. By seventh, eighth grade, if they don't already start knowing some of this stuff, essentially they're set up for a world of hate, a life of toil and torment and turmoil. Because essentially, as most people realize, if you earn a living, IRS is going to come for you. They want them taxes. If you own a house, they want them taxes. If you allegedly own a car, you got to pay that registration. Again, these are all offers to contract. And if you don't understand the contract, and of course, most people don't, if you have a contract with the state has however many thousands of codes, statutes, and regulations. And the Fed essence, if you're looking at the so-called federal government, there's close to 80 million estimated codes, statutes, and regulations. That's your terms and conditions. You want to contract with them? Go for it. Go for a pile of terms and conditions that you'll never even know. It's impossible for anybody to read and know all 80 million code, statutes, and regulations. Not possible. Not that I've seen. And even if you had an idyllic mind where it's like a photographic memory, you're still going to be stuffing it full of a lot of shit that don't mean anything. So ultimately, this is the big thing. And like Shogun was saying, there's a lot of word magic in this too. And the problem there is, if I write a contract and I use the word gray, and I'm thinking of the darkest shade of gray, you're thinking medium shade of gray, I've already written a contract that's deceiving you. And if I'm writing code, statutes, and regulations, and my intent is to deceive you, I'm for sure going to write gray with the intent in my mind as the darkest shade of gray, knowing that most people are going to think of a medium shade of gray, which means that I've already deceived most people. It's pretty simply done, and they put it right in your face too. The legal dictionaries are out there. People can get them. You can get them pretty cheap on Amazon if you buy the used ones. And you look up certain words, look them all up really, but certain words like includes is a great word to use as an example, because includes is actually exclusionary of everything else. So if I write a sentence, Shogun and I are going to go to lunch and Rokomo is with us, but he's going to come late. And if I write it to say Rokomo is going to be included, but arriving late, he's not arriving late because he's the only one that's going to lunch. Everything that was listed beforehand, Shogun and I, we're not going. Unless you write limited, includes but not limited to. If you write includes but not limited to, now everybody gets to go. Everyone. But this is little simple legalese bullshit that most people don't thoroughly understand. And since language, especially legalese, is extremely ambiguous, completely ambiguous, which means that you need to ask the other real party at all times, at any time, if somebody is offering to contract with you, what do you mean by that word? What do you mean by this word? What do you mean by that word? Yeah. Another way to deal with things in a way, like with cop, IRS agent, DA, whoever, since you know that it's all contracts, when they start talking to you to offer their contract, you simply say something like, great, you're wanting to contract with me. Okay, that's awesome. Well, here's my terms and conditions. My terms and conditions are 20,000 for the 20,000 for an hour. It's 20,000 for the first half hour and 10,000 for every half hour after that. So the first hour is a full $30,000. You want to contract with me? That'll shut a cop, a DA, an IRS agent down right now. They won't want to mess with you. And I know, because not only have I done this, but there are several other friends and brothers that have done this and had some great success, especially one brother up there in the area known as Canada, where he runs a so-called trucking company, and he's had to deal with the Ministry of Transportation, where they wrote a letter to him saying, we need to come see your records and check this and check that. And he wrote a letter back to him saying, great, and here's my terms and conditions. It's 20,000 an hour. They didn't show up. And then later, when they got really antsy and they did show up, they called the cops on him, and he showed them the letter that he had sent them. And the cops said, seems to me you got a contract. You better honor the contract or leave. They left. And here's another example of a way to contract, which is no words at all used verbally, no talking to anybody, but yet there will still end up being a meeting of the minds. Say you're in an area that snows a lot, and you write a letter to all your neighbors in the neighborhood saying, I'm going to clear your walkway for $20 a month. If you got a driveway, it's another $20 a month. And it's going to be every week that I'll do that. So you'll have your walkway and your driveway cleared every week. But if you don't respond, you still owe me. A lack of response is considered an agreement. The only way out of this agreement is if you pay me $50 up front. And even a lack of response on that is still an agreement that you owe me the $50 if you want out. This is how they teach contracts in contract law in law school. So, yeah. Anybody have any questions at this point?
Yeah, that was
my notes real quick.
Yeah, go ahead. This is going to be open questions and discussion. Thank you, Randmguy, for that excellent introduction. Go ahead, Mason.
Thank you so much for giving us a crash course about the contracts.
No worries, brother.
My question is, do you have a state license, or do you have like multiple state licenses?
Oh, I don't deal with the state. I don't believe in using state licenses. That, again, is a contract, an offer to contract. And if you do anything with the state becomes the major or the dominating party in interest. And I'll give you a prime example. Let's say that you get a marriage license, which seems to be rather innocuous for the most part. But yet, since the state is the dominating party in that contract, the two parties getting married, the husband and wife and wife, husband and husband, whatever the case may be, become wards as soon as you apply for a wedding license. You actually are applying to become a ward of the state. You're telling the state that you want to get married, but yet you're not completely competent to handle all your own affairs. So you need to have the state as part of the contract so that they can help you handle your affairs.
May I rephrase my question? If
Sure,
I may.
Go ahead. Sure.
Okay, so do you live in Canada, or you live in the United States?
Well, allegedly, I live in the area known as California in the United States of America.
Okay, so but even though, so you do not recognize the authority of the state?
Well, no, of course not.
Okay.
Yeah.
Okay. Thank you. Thank you so much.
No worries. No worries. And just as a quick idea, and it's not a matter of recognizing it, I haven't contracted with them. At least they have yet to produce the evidence that I have contracted with them. Saying that's the whole thing. I don't necessarily automatically deny or refuse or anything like that. I simply just ask for the evidence that there is a contract, that I have an obligation. And as soon as somebody can produce that evidence, then great. I have yet to have anybody produce the evidence, though. And that's the best part, is you just simply ask for whatever. And if they can't produce it, where's your evidence of your claim? Where's the real party in interest, the claimant? Because
Does
that's the
anybody
only.
else has a question?
Well, I
Because
was just going to say.
I would like to follow up.
Okay.
Go ahead
Well,
for now, brother. Go ahead for now. Get your train of thought out.
I was just going to finish saying that if you have a real party in interest, then that's the only one that can actually make a complaint. Because if a witness to a contract doesn't like something that you're doing, it doesn't matter. The only one that can actually complain about you and or your performance or whatever would be the only other real party in interest in the contract that you would have. So they're saying that if you say you're speeding, you're doing 40 over the speed limit. Well, the only person that could say that you were actually doing that and complain would be the state, even though the cop is going to act as the agent. But like I said, they're acting as an agent for a stack of paper with ink on it. They cannot exceed the capacity of the agent or the principal they claim to represent. So if a stack of paper with ink on it can start to talk, great. Now let's get it into the courtroom. Let's get it up on the stand and have it point to the cop and say, yes, that cop right there, I granted that man authority or woman to have a power over the public, so to speak, to do this or do that. Until they can do that, though, in fact, there is a case. It was US v. Rod Class. This case went all the way to the Supreme Court. Rod Class wrote a letter to Eric Halderman, who was the federal attorney general under, what was it, the Clinton administration, I believe it was. And he ended up having to retire or basically resign his position as attorney general. And the reason being is because Rod Class wrote a letter like I'm talking about, where they asked for certain things, put it in the language that a lack of response is going to be an agreement to such and such. A lack of response could be any number of things, including not answering a specific question out of a series of questions, not sending the correspondence back to the right address. Say, like if you're using an administrative process where they're supposed to send it back to the notary that you used to send the correspondence to them, anything like that becomes an agreement. Well, Eric Halderman and his entire staff just ignored the contract. They breached it. And the Supreme Court said, sorry, Halderman, you breached the contract. This was an actual contract. This is as good as it gets. Your ass is in a sling. That's why he retired. Or resigned, I should say.
Okay. I would still like to go ahead and rephrase my question one more time.
Okay,
So,
go ahead.
You're not certified to be a lawyer in the state of California where you live.
Okay, well, there's no certification and there's no licenses,
Okay.
just so you know. And of
But
course,
so you're not a lawyer in general at all.
well, actually, no. Well, hold on. A lawyer, the true definition of a lawyer is one that's learned in law. There is no necessary title or degree, I should say, or bar membership that makes one a lawyer.
Okay.
An attorney is one that attornment, which is the root word for attorney, is one that turns property for the Lord. Attorneys, bar member attorneys, are more loyal to the court than they are to their clients. In fact, in Corpus Juris Secundum, Volume 7, Section 4, I believe it is, says, and this is quoted out of a court case, that, again, if you hire an attorney, you're essentially admitting to the court that you're mentally incapable of handling your own affairs. You actually are admitting to and agreeing to being a ward of the court at that point.
I don't have any more questions. Thank you so much
No
for
worries.
you've been more than helpful to me.
Well, thank you for your question. I appreciate it because it brings some
And
stuff out.
yeah, thank you so much.
I'd
No
like to
worries.
point
you.
out something that I noticed. Phone companies or different services, they'll use that in their contract, that wording basically. If you don't follow a certain set of whatevers to
Mm-hmm.
stop them from continuing their service, even after a 2-year contract, let's say, they will continue to have that service and you would be charged unless you follow, jump through this hoop and that hoop first.
Right.
I like
Exactly.
how people are actually starting to do it themselves now.
Yeah. And in fact, like if you get say like a letter from a collection agency or a credit card company because you missed paying a bill, they will put wording in there where they say that if you do not respond and deny this debt, that it will be assumed that you do owe it. And we can take you to court on that. And the court will run with that assumption. They'll run with that assumption because if you can't prove that you don't, or ask the right questions and prove that they don't really have a loan that you owe. So that's one of the things. In fact, the next podcast will cover more on money, but all loans are essentially backwards of what most people think. When you apply for a loan, just the application alone gets turned into a promissory note. It gets sold for the amount of the loan, no matter whether you get the loan or not, which means that they just bought that application. You are now the lender to them as the borrower. If they actually give you the loan, that makes it even more so that they actually are still the borrower, the buyer, to you as the seller lender. All deposits that go into a bank, and it doesn't matter if it's into a checking or a savings or even a money market account, those are all loans to the bank, which is really kind of sad because it's only been in the last, 20, 30 years or so that banks have actually been doing interest-bearing checking accounts and better than normal interest-bearing savings. Well, the fact is, it should have been way better because they've been borrowing that money. They should have been giving you a hell of an interest rate. You look at how much they charge you for car loans, for house loans, and for whatever else. They should be giving you that interest rate to you when they borrow your money.
Thank you. Does anyone else have a question or comment for Mr. Randmguy on this excellent presentation? I have one. So, what you're telling us basically in a grander sense is this. There's really intelligent, well-educated people who've been given certain mental and knowledge advantages over everyone else, right? They've been able to afford special training, special education, and so they know tricks and secrets of the trade that the plebs, the ordinary people, don't know. And that allows them to basically take advantage of us and prey on us because we don't even know what a contract is or a mandate is or a law is or a money is, or and they do. So they have the magic and we don't. So what is step one, in changing the direction of this? What is the one thing that people can start to claim for themselves that they can actually use as plebs, against these elites, lawyers, or whatever? Is there anything they can start with or really arm themselves with in this fight so they can defend themselves?
The biggest thing I would say, if you really want to start understanding the system, get yourself 2 books. Most people are familiar with the yellow books that are this, that, or the other thing for dummies, contracts for dummies, trust law for dummies, how to build a house for dummies. Get contracts and get trust law, because every government agency is set up as a trust. All trusts are set up as corporations. All corporations are set up as trusts. It's all one big, giant, happy circle. So if you don't understand trust law, you're going to miss a few things. And then learn contract law, and understand that you're the only real party at interest. That's the biggest thing. Under the trust, all governments, well, I should say all government employees are trustees until you actually claim that legal name, which is another little thing that we've talked about in the past. Once you claim the legal name and that so-called social security number, you become the trustee. You just removed the public servant, the public or the GovCo agent as the trustee position, and you assumed it yourself. If you don't do that, you remain the beneficiary. The beneficiary essentially is owner of all property within the trust. The
How do
legal
you
name, what's that? I'm sorry.
How do you claim your own name and your own social security number, or in Canada, social insurance number? How do you claim that?
Well, you don't want to claim it. That's it. You wouldn't want to claim it. Because the thing is, I don't know how it is up there in Canada, but here in the United States, the Social Security card right on the back says, this card belongs to the Social Security Administration and you must return it when we ask for it. Well, the real issue here is they're not claiming ownership and they don't care about the less than a penny's worth of paper. They're claiming ownership of that information. They own the legal name and that number that goes with it. In fact, when I was in court one time, the judge called the legal name up. I said, I'm here for the matter. He asked if I was the legal name. And I said, well, I'm led to believe there's been a mistake. He said, what do you mean? I said, well, I'm led to believe that that name belongs to somebody called the Social Security Administration. And if that be true, it would seem to me that if I'm just to assume that name belongs to me, that I'm committing trespass to chattels. And if that be true, then that would mean that if I use that legal name as so-called personal identification, now I'm committing fraud. And I certainly don't believe I want to commit fraud, especially here in a courtroom. The judge didn't argue with me, didn't say anything other than, well, what do you suggest we do? And I asked him, well, could you call me friend of the court or peaceful inhabitant? And he said, okay, Mr. Peaceful Inhabitant. Well, right there, that Mr., as opposed to just peaceful inhabitant, was him applying a term and condition. It was an offer to contract. Had I let that slide, I would have been in his contract. I asked him, well, wait a minute. Where did the Mr. come from? Could it be that I simply asked you to call me peaceful inhabitant or asked you? He said, okay. And even a little bit later, when he said that I needed to come back for another hearing date, I asked the judge, would it be okay if I come back on such and such date and help settle this matter? What I did at that point is I took his order away, his offer to contract, and I asked permission if it would be okay. I put my own terms and conditions in it. And literally the very next hearing date, the DA met me in the hallway and told me charges have been dismissed. You can go home. We don't need you anymore.
Just like that.
Just like that.
Is that because you knew the game?
Mm-hmm. And this is after I had been dealing with this legal issue for close to 2 years and tried some other stuff that basically it held him off for about 1.5 years, but it didn't do anything to get me out of it. What got me out of it is starting to ask to meet the claimant. And when anybody, DA, judge, whatever, would make a claim, I'd ask, are you assuming liability for that claim? When the judge did it, and it was the supervising judge of the courthouse, he ran out of the courtroom. When he came back about an hour later, cleared the rest of the courtroom, and he calls the case back up, the first thing out of the mouth was that a yes or a no? He ran out of the courtroom again. And when he ran out the second time, as he went by the court clerk, he told her to set for another hearing date in front of another judge. That's the judge that I said, I believe there's been a mistake over the name. So I was literally, at that point, I was 3 hearings out from the thing being done with.
Acquitted because it could not be attached to you.
Exactly, pretty much. Because they couldn't get me to admit to being the name. They have to have you admit to being that name because the name doesn't belong to you. And that's, again, the only way that they can get you to become the trustee. And this is part of why, if anybody's ever heard of prisoners in jail being called trustees, that's why.
Never heard of it, but I'm sure I will.
I have.
They don't use it. Yeah, okay. Well, there you go. Yeah, because
Aren't they referred to as trustee of the court or something like that? Or trustee of the state?
Yeah, and or wards of the state, either one, yeah. because essentially, when it comes down to it, most people don't realize that if you claim to be a citizen, you just gave them jurisdiction. You claim the name, you've given them jurisdiction. And not only are you giving them jurisdiction, you're essentially, especially with the name or a citizen, you're actually claiming to be their property. And this is where a lot of people get very upset when people say, oh, they're killing these people and they're ripping those people off and they're doing this and they're doing that. Well, no, they're not. Yeah, they are, kind of. But the thing is, if it's their property, they're allowed to do whatever they want with their property. And if these people want to continue to admit to being the property of something called government, well, who am I to get in their way? So that's where the problem comes in. Is if you're volunteering for it, you're not a victim, you're an accomplice. If you're voting, you're not a victim, you're an accomplice. Because there's two wings, one bird. Left side and right side have to work in unison. People think, oh, well, the left side of the Congress and right side of the Senate and this, that, and the other. No. Two wings, one bird. And the air does not know which side it's supporting. It just supports equally. So, yeah, it really kind of comes down to if I want to burn my house, and especially if I want to burn it and not go for so-called insurance fraud, well, it's so-called my property. I can do whatever I want with it. And this is part of why I wanted contracts to be first, why I wanted to talk about it, because when you admit to and or you agree to these things, and most people don't understand how they're agreeing to things, because the system works literally 180 degrees out from what most people think. That we could even we'll find even more when we go into money in the next podcast. But yeah, everything is 180 degrees out from what most people think.
Thank you for having this podcast. You've been talking about it for so long. This podcast is well overdue.
What's that, brother? Was that Jakar I heard in there, brother?
Yeah, I was just saying thank you for this.
Hey, brother, I haven't talked to you in a while. How you doing, man?
I don't know, but this podcast is on record, so I'm gonna shut up.
All right. So, yeah, if anybody has any more questions or comments, I'll be happy to answer anything if I can.
I have a question, but I'm waiting for anybody else who might have.
Go ahead,
just go
Jakar.
ahead.
Just go ahead. Yeah, thank you.
All right. Well, not necessarily a question, but I wanted to say that what you're saying about the association between names that governments gives, like, numbers and all these sorts of things, also apply. Even though this is a tiny bit off topic, it really is not. Goes towards a certain rule of allowances, as I like to call it, in which contracts are made between humans and entities that they affiliate with, and in fact has the exact same principle behind it, of which has attachments behind the contracts and what they entail. For example, was doing something about 2 weeks ago that, while I was doing it, said if you were to continue doing this, you would die. And I said the words, okay, and plus entities don't really interact with me with English anyway, so I did it. Ended up with a detriment, but realized only a day or two later that what had just happened before then was a type of contract saying that you would die. Me saying okay, accepting the terms of the contract, made it to where that possibility would manifest. And in fact, the government does use the same thing.
Well, yeah, government, like I said, everything government is always going to be one of two things or a combination thereof. So, like in the essence of a courtroom where a DA is going to try to get you to negotiate for a plea deal, and there's going to be the judge and all this. Well, like I said, those guys can't actually contract if you realize that they can't exceed the capacity of their principal. But as long as you do believe it, and you're, again, he who will be deceived, let him. Yeah, they put a piece of paper down in front of you, essentially, as that entity, because the entity really is going to still be the state. They're representing the state. And when you essentially, like if you're in a plea deal, they'll put all the information down there and they'll have you initial a bunch of different questions or things where you not supposed to have any firearms, no deadly weapons, no knives, this, that, and the other thing, no illegal drugs, whatever, no violations, whatever, and you're supposed to initial each one, and so on. Of course, one of the things that I've found and that actually worked pretty well, kind of messed them up, is when I signed some of that paperwork with the words "not me." They looked at that shit and went, "Fuck, what are we going to do with this?" Because they didn't have a contract. They thought they did at first until they looked at that. Because when I questioned them, they said, "Well, we got a contract. Really? Show me the signature." And they changed the subject. They didn't want to continue down that path because they realized that they didn't have a signature on anything. Even though they stood there and watched me put ink on the paper, they realized that I didn't sign it at all.
Right. You can put any words down there that you want, really, and they have to pay attention to assume that you put your actual signature there for you to have agreed to that contract. So it's funny that they even looked.
Oh yeah, Well, yeah. Well, it's because I was calling them out on it. Like you said, we got a contract. Really? Show me the signature. That was the whole thing. Is because I directly put their attention to that because I knew that as soon as they saw that, they were going to go, "Fuck."
It's great. It's great that it worked out in your favor. Hopefully in the future it continues to. But you're so right. One thing you said is the wording and how things are worded, and what you say in response makes the absolute 100% difference.
Oh, absolutely. And of course, in my world and way I see things, I'd let them talk, say whatever, and then I'd ask them specifically a couple of questions. Like, first, are you assuming liability, and or depending on what do you mean by that word? Either one is pretty fun, and I don't do everything just to shut the situation down right away. Sometimes I like to, kind of like a cat plays with its food.
Play around.
Sometimes when it's when it's smacking a rat around before it eats it.
It gets them to realize some things too. A lot of them
Well, yeah, of
just
course it does. Of course it
don't
does. Because
realize.
when they have to think about the answer, that gets their brain clicking. And all of a sudden they start to realize, like I've said before, like with if you ask a cop, okay, great, you want a contract with me, these are my terms and conditions. That makes that cop start thinking, and he don't want to have anything to do with 20,000 an hour, 20,000 for the first half hour, 10,000 for every half hour after that means the first hour is 38,000. And I don't want to touch that.
No, because if they do, they're going down a rabbit hole. They might even win in the long run if so you slip up or anybody in your position would slip up. But in that case, they spent too much money and time on one person.
Well, one of the things, and this is what part of why I do some of the things that I do, say like with the judge that I had run out of the courtroom. If I had to sue that judge, I wouldn't sue him as the judge. I wouldn't sue an IRS agent as an IRS
Civil.
agent. I would sue him as the real man. I would sue the judge as Andre Mansourian, not Judge Mansourian. Because if I sue him as Andre Mansourian, the real man, now the burden is up to him because he's going to have to try to protect himself. So if he's in a courtroom, he's going to say, I was representing the state. Well, as soon as he says that, he just made the claim to represent the state. Now he has the burden of proving that. Onus probandi. He who makes the claim has the burden to prove that claim. And if he cannot prove that claim with evidence, that claim must be found against him. Well, as soon as that judge says, I'm working for the state, and he can't get the state to step up on that stand and point to that judge and say, yes, I appointed that judge as a judge to have authority over people. He's done. Until he
Right.
can
Well, I mean,
prove it,
if you're
he's
suing him as
done.
a person, if you're suing him as a person and not the judge in his official capacity, you're suing him as an equal, as a civil case. And in that case, you'd have to have a civil reason, a personal reason of why you would be suing that person. And yes, they could not defer to their state associations or federal associations to help them. They'd have to use their own resources.
Right. Well, of course, if you're talking about, say, like a judge, and this is something that I've had happen. It hasn't happened for a long time since they stopped messing with me, but say you get reincarcerated. Does that damage you? Well, yes, it does. Of course it does. You're being thrown back in a cage and you're going to lose some freedom and so on. And of course, that's all you need for a civil tort case. That's all you need. If you're damaged in any way, in the slightest way, and of course, judges know this. That's why that judge ran too, because he knew as soon as I asked, "Are you assuming liability for that?" Number one, if I did get injured in that, he was the one that was going to have to be responsible. But also, too, when you recognize what a judge does when they put in a plea for you, if you understand that they just made the claim in court, in an open court, that you're not guilty, which means that it's now the judge's responsibility. It's his burden to prove to the DA that you're not guilty.
If you assume responsibility, it alleviates that pressure, right?
Well, the whole thing is they know that if they don't, the lawsuit is what's coming next. That's the whole thing. They know that their asses, the crosshairs are lining up on their ass, and they're about to take one, and they're going to take it hard too.
Beautiful.
So, yeah, that's pretty much it. And hopefully, I made this enjoyable enough and interesting enough that everybody didn't fall asleep, because I know contracts can be rather boring.
I have a question.
Absolutely, brother. Go for it.
At first, I desire to say that this is a very empowering podcast, and I can feel the power from it. But what was that name that you used instead of your name when the judge was trying to call you Mister?
Oh, peaceful inhabitant. Peaceful inhabitant.
Peaceful inhabitant. Thank you. That's all.
Yeah.
Good
Yeah, no
citizen,
worries.
not me.
Well, I asked them if they could either call me friend of the court or peaceful inhabitant, and both of them are actually kind of key words. Friend of the court is a key word, a key phrase, because there's actually a position called friend of the court where you can actually be in court helping somebody and not actually even be learned in law as a lawyer, non-bar member, or whatever. Oh, and here's something too, real quick. I don't know. I believe I mentioned earlier, but about license for so-called attorneys. There is no license. This is something that most people don't recognize either. People say, "Oh, they're a licensed attorney." No, they're not. He's a licensed lawyer. No, he's not. He's a licensed bar member. No, he's not. The bar is a membership. The bar is a membership club, and the only thing they have is a membership. Now, they can allegedly suspend through your membership your right or your ability to practice law, but yet it's still not a license. And I've actually read through the entire thing on the bar, on their website. I've read all the codes, all the statutes on this, and asked professors questions in law school, and along with other students that knew some of this stuff, the professor lied straight up, said, "Nope, that's not a membership, it's a license." And these other students and I were just laughing our asses off because we knew that the professor was lying right then.
Well, this has been great. Thank you so much, Randmguy. Is there anyone else who wanted to squeeze in one more question when you have a chance?
Not a question.
Anything?
Thank you.
Anything at all, guys. Anything you can think of, throw it at me.
Randmguy. This was great. Great stuff. If you haven't heard our previous podcast with Randmguy, we did one on steroids and testosterone. You can find that in the Roundtable podcast, the Roundtable server, I think. I don't think we have it up on our YouTube yet, but it's in that channel. And the other ones are all on the Roundtable podcast, which you can find in the hashtag RT podcast channel of the Temple Mount server right up at the top. And we'll be doing more in the future. So thank you so much, Randmguy. That was great. Good stuff, important stuff. Anyone who wants to be a guest on the Anyone who wants to be a guest on the Temple Mount podcast, just send me a DM with your topics of interest and we'll set it up. And keep an eye on the announcements channel. There's always new stuff.
You got cut out.
Shogun, we can't hear you anymore.
Yeah, it cut out for a second there. I have a bottle on the screen.
Is he back?
I'm going to disconnect him.
Hmm.
I think he'll see that. Shogun, I'm disconnecting you so that you can reconnect. You have a
Hello?
signal.
Hello?
Or-
Sorry, I don't know what happened there. I got disconnected. Can you hear me now?
Yep.
Yep.
Sorry
Yeah,
about
you cut
that.
out.
Yeah,
No
sorry
worries.
about that. I think it's because I left the sushi place and I left the Wi-Fi, but
Yeah.
and it dropped out. But I was just saying, we have two channels I want you guys to be aware of. One is the Temple Mount SoundCloud channel that Hugh is managing. So if you look at that, he is managing all the SoundCloud uploads for the Temple Mount podcast, as well as the previous Roundtable podcast, which is now retired and finished. But you can still find all those great episodes. But keep an eye on those two channels, the Temple Mount SoundCloud and the Temple Mount podcast. And you'll find all our great daily episodes recorded, uploaded. We got paid professional staff, and they're doing a great job. So please check out the first episode of the Temple Mount Church on the Mount. And this is the third episode of the Temple Podcast. And we're going to have Drewish on soon to read from his book, which is really great. You know, an author reading their own work is really cool. Drewish's stuff is really good. Just keep an eye on the announcements channel. My one thing I ask you guys from the bottom of my heart, just check that announcements channel. You know, we make those announcements so you guys know what's going on, so you can access this great content. And it's all for nothing if you don't read the channel. So please read the announcements channel. I beg you. Thank you, Random Guy.
Thank you, guys.
And thank you, everybody, for attending. I love you guys. Another great day. Let's celebrate. I'm going home to smoke some weed. I hope you guys will join me. Let's jump up to the video chat.
Let's go.